Fifth case item 22. First step is 138 of 2023.
Date yesterday, my lord has heard the matter. Suit and all specific performance.
10:30 हाँ आप पार्ट डिक्टेशन किया हुआ है उसको कर लेते हैं उसके बाद आइए
From supplementary list item was second case 68 of 2005.
the learning code thereafter. Consider the evidence of PW4. And also PW7. And recorded that the Until report being a public report was admitted by both the parties and was marked Exhibit 3 and was a public document. The court also recorded that a perusal of Exhibit 3 would make it clear that the so-called grievance and complaint of the plaintiff before the Until Adhikari make it clear that the plaintiff had filed a grievance and complaint before the Until Adhikari, and pursuant thereto, the Until Adhikari Kuchai submitted his report stating the fact that disputed plot has once been settled with the plaintiff in the settlement case number 53 of 7071, which was, however, later in the year 1975 was settled in favor of the defendant. The court recorded a finding that Exhibit 3 leaves no room of doubt that land was subsequently settled with the defendant. The court further recorded that there was no whisper of any kind of fraud from the side on behalf of the plaintiff. That the defendant had played any misrepresentation in getting the subsequent settlement of suit land in his favor by the Exhibit B. and further recorded that Exhibit B contained the writing of clerk Madan Mohan Prasad and signature of Anchal Adhikari Abdesh Kumar Singh. The court recorded that the manner of acquisition through Exhibit B was not under challenge. The learned court was of the view that there was a specific finding of the learned trial court by paragraph 22 of the judgment that the earlier settlement of the plaintiff by the Exhibit 1 being prior in time shall prevail. But the first appellate court was of the view that such finding cannot be sustained in view of the principles laid down in the judgment reported in 1978 SC 556 that in case of conflict between old and new record of rights, the later entry will be presumed to be correct unless shown to be wrong. The court further recorded that the genuineness of settlement entries of Exhibit B in favor of the defendant was not attacked by the plaintiff on the ground of any fraud or forgery. The point of possession was also decided in favor of the defendant. The learned court, first appellate court recorded that from the analysis of evidence, it was established by preponderance of proof that although the plaintiff was previously settled with the possession of the suit land of plot number 1149 by the Exhibit 1, settlement Parwana dated 16/8/70 in settlement case number 35 of 70/71, and yet he lost his title and interest over the suit land because of the subsequent settlement of the suit land by settlement Parwana dated 30/6/1975 in settlement case number 3 of 76 that remained unchallenged, unattacked on any ground of fraud, collusion, deceit, etc. And ultimately the three issues, that is issue number 7, 8 and 9, were decided against the plaintiff/respondent. And the title appeal was allowed. The learned counsel for the appellant, while assailing the judgment passed by the learned first appellate court with reference to the substantial question of law involved in this case, has submitted that the learned first appellate court has miserably erred in law by holding that the suit was to be governed by Article 58 of the Limitation Act, and therefore the suit was barred by limitation without meeting the reasons cited by the learned trial court to hold that the suit is governed by Section 65 of the Indian Limitation Act. The learned counsel has submitted that Article 58 of the Limitation Act is not attractive in the present case, as it is, as the plaintiff was not only seeking any declaration but was also with an alternative relief of recovery of possession on the basis of title. And therefore, Article 65 was clearly attracted. The learned counsel has further submitted that the appellate court has also wrongly set aside the finding of the learned trial court with respect to legality and validity of Exhibit 1. And has not met with the reasons cited by the learned trial court. यही तो आपका submission है. The learned counsel appearing on behalf of the respondents has submitted that the judgment passed by the learned first appellate court is well discussed. He has in particular referred to the findings recorded in paragraph 8 onwards, 8 to 15. 8 to 15. Eight to 16 is the learned counsel for the state has referred to the judgment passed by Honorable Supreme Court reported in bracket 1999 bracket close 4 SCC 350 paragraph 14 to submit that The appellate that in second appeal, the judgment passed by the learned first appellate court cannot be interfered on the ground that the first appellate court has not come to close grips with the reasoning of the trial court. However, he has submitted that the substantial question of law as framed by the order dated 23/6/2009 is required to be answered. Okay. After hearing the learned counsel for the parties, and upon going through the pleadings as mentioned above, this court finds that the plaintiff claimed settlement with respect to the suit property by virtue of order of settlement dated 16/8/70 in settlement case number 35 of 70/71. Said to have been settled by passed by the order of subdivision officer, said to have been, and the settlement issued by Anchal Padanikari in the name of the plaintiff. This fact was denied by the defendants in their written statement by paragraph 8. And the defendant denied the very issuance of settlement in favor of the plaintiff. The plaintiff, further in the plaint, has specifically assailed the issuance of settlement in favor of the defendant by Exhibit B in paragraph 6 that define all canons of law. The defendant number 1 has managed to take settlement of plot of the suit plot from D. Anchal Padanikari of Kuchai on 36/75. And that prior to issuance of such settlement, there was no publication or istihar calling for objection. Hence, the plaintiff could not file any objection to the issuance of settlement in favor of the defendant. the plaintiff had sought relief seeking a declaration that the defendant number 1 has not acquired any right, title or interest and possession with respect to scheduled suit land on the basis of settlement dated 30/6/75 and the settlement was illegal, void ab initio and does not confer any title on him, and also sought a declaration that the plaintiff has right title and also sought a declaration of plaintiff's title and confirmation of possession over the suit land, declaring that the settlement of suit land with him made in settlement case number 35 of 71 was valid, and also sought a relief of recovery of possession of the suit land if the plaintiff was found dispossessed. As per the plaintiff, the cause of action arose on 15/3/1983 when the executive magistrate, in a proceeding under section 145 CRPC, passed in miscellaneous case number 144 of 1983 by order dated 8/6/19, declared the possession of the defendant number 1, against which the plaintiff and the said order was confirmed in criminal revision number 100 of 1983 and ultimately in criminal miscellaneous number 2384 of 1990 within bracket R. It was observed in the month of January 1991 and ultimately in criminal miscellaneous number 2384 of 1991, and finally in the month of January 1991 when the defendant number 1 made an attempt to dispossess the plaintiff from the suit land. Considering the aforesaid facts and circumstances and the nature of relief sought for by the plaintiff, this court finds that the suit was not a simple suit for declaration, to be governed under Article 58 of the Limitation Act. But was also relatable to possession of immovable property or any other interest therein based on title. The plaintiff claimed title on the basis of settlement based on the order passed in settlement case number 35 of 1971 and filed the suit when the defendant number 1 threatened to dispossess the plaintiff and the plaintiff was found not to be in possession in a proceeding under section 145 CRPC. You were not found in possession, no? In 145?
His possession was declared.
his possession was declared, and the possession of the defendant was declared. In the suit, not only the title but also the possession was under dispute. This court finds that the learned trial court, by considering the point of limitation, by deciding issue and the cause of action by deciding issue number 2 and 5, has considered this aspect of the matter these aspects of the matter and ultimately held that the suit will be governed by Article 65 of the Limitation Act. And even if the date of knowledge of settlement in favor of the defendant is taken into consideration, that is May 1979, then also the suit was filed within the period of limitation. The court also recorded that the defendant attempted to dispossess the plaintiff in the month of January 1991. The learned first appellate court, by considering the point of limitation, point of cause of action and the point of limitation, has simply referred to Article 58 of the Limitation Act by deciding issue number 2 and 5, has recorded that the actual invasion of the right, title and interest of the plaintiff was caused by the defendant either in the year 1979 or on 25/5/1980. And also observe that, and also refer to the order passed under section 145 CRP, and observe that the plaintiff never chose to challenge the settlement of land in favor of the defendant before any forum under the Total Tenancy Act. The court, while referring to Article 58 of the Limitation Act and claiming that the suit was barred by limitation, failed to consider that the suit was not a simple suit of declaration, but in the suit, the plaintiff claimed settlement in his favor prior to the settlement made in favor of the defendant, and the suit was filed after the possession of the defendant was declared under Section 145 CRPC, and also a cause of action that the defendant number one threatened to dispossess the plaintiff. This court finds that the learned first appellate court has erred in law in applying Article 58 of the Limitation Act to the suit and has erred in setting aside the finding of the learned first appellate court on this point. The trial court on this point, which has based its finding on Article 65 of the Limitation Act, while holding that the suit was filed within the point of limitation. This court further finds that so far as the validity of settlement, so far as the rival dispute between the parties on the basis of Settlement Exhibit 1, which was made in favor of the plaintiff in the year 1970-71, in settlement case number 35 of 1970-71, and the claim of the defendant on the basis of settlement made on 36-70-75 in settlement case number 1975-76. The learned trial court has considered the materials on record including Exhibit 3, Exhibit 1 and Exhibit 3. Exhibit 1 being the settlement in favor of the plaintiff, and Exhibit 3 was the letter containing the report of Antal Adhikari that a settlement was made in favor of the plaintiff. The court had also considered the documentary evidence, the oral evidences, and ultimately came to a finding that settlement was made in favor of the plaintiff and the settlement of the defendant number one was at a later point of time and therefore held the that the settlement of the plaintiff was valid. The court also recorded that the plaintiff was dispossessed from the property as the possession was declared in favor of the defendant and consequently directed for recovery of possession in favor of the plaintiff. So far as the learned first appellate court is concerned, while considering the legality and validity of Exhibit 1, the court referred to the evidence of PW2, who has exhibited the settlement within bracket Exhibit 1. And had stated that the settlement was in the writing of Mohan Soy and was having the signature of Chittaranjan Jha, and that Chittaranjan Jha was block development officer but was in charge of the circle at the relevant point of time. The court recorded that the court discarded the evidence of PW2 by holding that he was not the competent witness. The court also recorded that the plaintiff had not brought any official record of the proceedings and recorded that the plaintiff failed to discharge his burden of proving his best claim. However, at the same time, the court recorded that referred to Exhibit 3, which was an admitted document and also a public document as recorded by the learned first appellate court, which was a report of the circle officer stating that the property was settled in favor of the plaintiff and it was subsequently settled in favor of the defendant number one by Exhibit. The court, while considering the settlement document of the defendant, observed that it was a public document and the plaintiff had not challenged the same. However, from the perusal of the plaint itself, it is apparent that the plaintiff had specifically challenged Exhibit B and had also asserted that Exhibit B was issued without issuing the Ishtihar, and therefore the plaintiff could not raise any objection with respect to issuance of settlement in favor of defendant number 1. However, in the court simply observed that Exhibit B was not attacked by the plaintiff on ground of any fraud or forgery. The learned court was of the view that the learned trial court had wrongly held Exhibit 1 valid, being prior in point of time, and has cited reason by stating that subsequent entry in record of right will have to give way to the old entry. This court is of the view that such finding is especially perverse in view of the fact that the parties were claiming settlement through procedure of law, and they were not claiming any right any right arising out of entry in record of rights. The plaintiff was claiming by virtue of settlement case number 35 of 7071, and the defendant was claiming settlement by virtue of settlement case number 3 of 7576, and settlement document was issued in favor of each one of them. And Exhibit 3, which has been duly considered and was an undisputed document, itself reflected that the settlement was issued in favor of the plaintiff number 1 prior in point of time as compared to that of defendant number 1. And in the inquiry report, the circle officer never stated that the settlement was never issued in favor of the plaintiff. The judgment passed by the learned first appellate court, while holding that the settlement was, while holding that the settlement in favor of the defendant was valid, not only suffers from misreading of the plain and the written statement, but also suffers from not properly considering the reasons given by the learned trial court by holding that the settlement in favor of the plaintiff was valid. Rather, the reasons for setting aside the findings of the learned first appellate court on the point of validity of settlement and also on the point of limitation is perverse. पोजेशन पे कॉन्करेंट फाइंडिंग है ना, पोजेशन पर
Disposition.
the in view of the aforesaid facts and circumstances, this court is of the view that the learned first appellate court has not correctly met with the reasonings of the learned trial court while reversing the findings of the trial court. And the judgment passed by the learned first appellate court cannot be sustained in the eyes of law. The substantial question of law is accordingly answered in favor of the appellant. Consequently, the judgment passed by the learned first appellate court is realized citizen. That's all. Appeal allowed.
ट्रायल कोर्ट का तो
ट्रायल कोर्ट का सस्टेन करेंगे, रिवर्सल है. और टाइम एक्सटेंशन उसका जजमेंट नहीं हुआ.
From supplementary as follows item 2, second appeal 88 of 2019.
कितना दिन का टाइम है? इलेक्ट्रिक काम बताओ. कहाँ इलेक्ट्रिक? Essay number 88 of 2019. This appeal has been listed at the instance of the office. A letter dated 9/9/25 has been placed on record, which is a letter issued by the Principal District and Sessions Judge West Indian at Chaibasa, seeking 3 months' time. Is seeking extension of time. On account of the fact that the petition under Order 6 Rule 17 has been filed which was disposed of and the order was challenged before the High Court in CAP number 601 of 2020. A period of extension of 3 months has been sought for. The time is hereby being satisfied. Time is the extension of time as prayed for is allowed.
This was a dispose of matter.
Dispose of matter.
Yes. This appeal, second appeal was a
Yes,
dispose
yes,
of
I
matter
know.
with direction to conclude it in 3 months. It has been
I know.
concluded on 11th.
Decided
Yes, I got the short order.
because
What is not order?
on 11th.
Yes, I know.
On 19th November it is showing pending.
No, I got
Extension.
Next date of hearing is 19th November 25.
I got a status.
Status also. It has been disposed of.
On 11th.
Make up the status. The execution case का status मंगा लो.
The execution pending है.
वो तो pending.
2197.
नहीं just a minute. फिर से लिखिए.
Filing number is.
एक सेकंड.
sorry,
essay
registration
number 88 of 2019. The learned counsel for the respondent
Yes.
submits that the case has been disposed of by the learned first appellate court.
Done and executed. It was 2197 application. Court name I'm not reading, but the registration number was MCA 49 of 18. And it has been disposed.
No, that is not correct. Anyways, I've given extension. If it has already been disposed of, it's okay. I've allowed extension of time.
As a
I've allowed extension
civil
of
judge,
time.
as a court is a civil judge, senior judge.
I've allowed extension of time. If it is disposed of, it's okay. The letter had come back much earlier, in the month of September.
We were also supposed to file a CMT because the judgment data was unnecessarily taking time. On one pretext or the other, he had moved up to 27 applications that was dismissed because.
Anyways, if it has already been disposed of, there is nothing to say.
From date is 50 item 22, first April 138 of 2023.
Plaintiff sued for district performance certificate and day before yesterday my lord has heard. And on the last occasion my lord was going to paragraph 5 and 6 of the claim, comparing with the exhibits. माइनॉट एग्रीमेंट देख रही थी, इसमें 50 लाख रुपया माइनॉट का क्रेडिट है, क्योंकि 50 लाख रुपया एडमिट किए नहीं किए उन्हीं को मिला। सो माइनॉट हैज गॉन थ्रू एग्जिबिट 101/01
Exhibit number
01/01, that is agreement to sell dated 17/12/2014.
1 by 1.
जी,
This is dated.
this is dated 17/12/2014.
Subsequent date. Second one.
सेकेंड वन, क्योंकि पहला वाला में था कि
पहला वाला तो कर लेंगे।
पेमेंट आप करेंगे तब फ्रेश एग्रीमेंट करेंगे। 25 लाख का पेमेंट हो गया, उसका हो गया, और इसके बाद पैराग्राफ 5 and 6 में माइनॉट का स्पेसिफिक क्वेरी है, कहाँ आप चेक का डिटेल लिखे हैं, which is pleaded in different, माइनॉट has taken note of it, and thereafter माइनॉट so माइनॉट D20 for the paid the substantial payment of amount to 58 lakh माइनॉट, and
Out of 76 lakhs.
yes. And 3 checks were also issued, handed over as a security for the at the time of registration and execution of registered deed of sale.
This was for how much?
This was for 15 lakhs. We read in para 7 of the claim.
What do you mean by security?
क्योंकि कभी-कभी लगता है कि पेमेंट होगा कि नहीं होगा, in order to show the conduct कि भाई हम पेमेंट पूरा कर देंगे, तो in order to show this, otherwise by proving 50 lakhs by the plaintiff to the defendant it is well. अब इसके बाद एक है मतलब कि हम इस पे था कि प्रायर परमिशन, जो कि एक खास मान लीजिए इसका रिन्यूअल हो गया था, एक का नहीं था। अब प्रायर परमिशन वाली जो बात थी कि ये जो नीचे लर्नेड ट्रायल ने बोला कि ये अनसर्टेन है, क्योंकि प्रायर परमिशन तो लिया ही नहीं है।
चलो एक बार प्लेट निकालिए।
जी,
प्लेट का शेड्यूल है,
प्लेस का शेड्यूल
शेड्यूल A, right?
होल्डिंग नंबर 242 है।
242 and 242. Plot numbers भी different
जी
हैं,
जी जी, सब कुछ है और बाउंड्री भी है।
बाउंड्री भी है। तो किसका परमिशन मिल गया?
परमिशन भी क्या था, ये ऑर्चर्ड शेड्यूल बी वाला जो है उसका परमिशन नहीं
शेड्यूल B में तो ऑर्चर्ड नहीं
है, 2 एकड़ 4 डिसमिल है।
है। अच्छा, इसका परमिशन
प्लेट में भी लिखा हुआ है।
जस्ट अ मिनट। शेड्यूल A and B है। शेड्यूल B का परमिशन ग्रांटेड, परमिशन टू सेल,
सॉरी रिन्यूअल
रिन्यूअल ग्रांटेड। व्हेन
एक तो ये अप टू 31/3/2038 तक चलेगा।
व्हेन डेट ऑफ रिन्यूअल,
This is
This is exhibit number.
one later has been exhibited as exhibit 4.
Exhibit 4.
Yes.
Dated.
This is the खास मान later mirror.
Dated. Exhibit 4 तो नहीं है ये. This is RTI. Exhibit.
This is मतलब dated 20/5/2013.
Exhibit number बताइए.
Exhibit number 4.
नहीं, exhibit 4 ये नहीं.
मतलब ये गलत है, मतलब ये मेरे पास है, ये गलत रिकॉर्डिंग है।
किसमें गलत है?
ये जजमेंट में जो एग्जिबिट 4 दिखा रहा है मतलब
हाँ.
इसमें जो लेटर है खास मान लेटर नंबर ये 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 जो इस लेटर को एग्जिबिट कराया गया रिन्यूअल ये रिन्यूअल हो गया वो लेटर ये हमारे पास है रिकॉर्ड में भी है दैट है क्योंकि वो जजमेंट में भी वो लिखे हैं एक पेज है जजमेंट का पार्ट इन्होंने लगाया है लर्निंग ट्रायल कोर्ट में ये पार्ट है पेज नंबर में my lord will get it
past 13.
Yes.
The exhibit का marked है. It has not been marked exhibit. This document has not been marked exhibit. Exhibit 4 is something else. RTI. With the exhibit name.
This is the part of the judgment that because it was filed by the plaintiff and the learned trial court has made it part of the judgment, internal page 19. Which my lord very much when it was reviewed from evident from the perusal of this letter, my lord will find it that this schedule B, folding number 243 was reviewed.
The court has termed this as exhibit 4.
Yes, my lord, on the top, my lord will substitute internal page 19. सबसे पहला लाइन में 19 पेज नंबर में जो पहला लाइन लिखा हुआ है DT.13.11.2025 एक्टिविटी नंबर 4 इन which it shows that उसके बाद पूरा लिखा है
RTI के साथ इसकी कॉपी है. RTI वाले लेटर को मार्क कर दिया. This is dated 20/13. Okay. When was the suit filed?
The suit was filed under 2016, 154 2016.
1/59/2016. Is there a letter को पढ़ी? Can you read this?
जी बेशक मोदी राजनामा सरकार की सेवा में उपयुक्त नदी और ग्राम पूर्व बागवानी पट्टा होल्डिंग नंबर रकबा 2.04 एकड़ भूमि का श्री अभिजीत नारी एवं अन्य के नाम लीज नवीकरण के संबंध में निर्देशानुसार उपयुक्त विषय अपर समाहर्ता हजारीबाग के पटना 108/खास महल दिनांक 23/3/2013 के द्वारा आयुक्त उत्तरी छोटानागपुर प्रमंडल हजारीबाग के द्वारा प्रेषित अभिलेख संख्या 47/07-08 मूल रूप में संलग्न करते हुए कहना है कि ग्राम बागवानी पट्टा होल्डिंग नंबर 243 प्लॉट नंबर 67 दिनांक 67 तक के लिए 31/3/2038 तक के लिए श्री 67 के नाम निम्नलिखित शर्तों के अधीन लीज नवीकरण की स्वीकृति दी जाए। लीज धारी को सदमी के रूप में 5,78,381 रुपया भू राजस्व प्राप्ति 0029 के अंतर्गत सागर में जमा करना होगा। दिनांक 1/4/2008 से वार्षिक लगान ₹1785 अलावे शेष लीज रेंट इंडेक्स फैक्टर में निर्धारित दर के अनुरूप तय होगा। प्रश्न नंबर भूमि मात्र बागवानी प्रयोजन के लिए रहेगी।
So these conditions were satisfied?
Yes.
No. There is a condition for payment.
हाँ, उसमें चालान भी प्रोड्यूस किया गया है, मैटर है उसमें चालान। That's what I'm saying.
अच्छा, ये जमा हो गया। So this is in connection with only
Holding number those of
243.
जी.
And what about the other holding number?
Holding number उसके लिए भी मैटर has taken note of taken cognizance that building अभिलेख संख्या 4707 उसमें रेफरेंस था जिसमें परमिशन दिया गया। इसी तरीके से 46 जो एग्जीक्यूट 1 by 1 है वह इसको खाली देखा जाएगा।
उसमें क्या बात है?
इसमें ये दिखाना चाहते हैं कि इसमें ये चीज दिया हुआ था कि दोनों का अलग अलग रिन्यूअल केस नंबर से वो ऑलरेडी रिकमेंडेड हो गया था, वही दिखाना चाहते हैं।
It was recommended on 17/12.
हाँ, नहीं तो ये जो इसका है ना DT 101/01
Yes, 1 by 1.
तो उसमें पेज नंबर 2 है।
Page number 2 तो agreement of sale.
हाँ, एग्रीमेंट टू सेल।
हाँ.
मतलब पेज नंबर 1 वहाँ है, फर्स्ट पेज नोटरी सर्टिफिकेट है, सेकंड पेज पार्टी पोजीशन से डिटेल्स है। उसी में फर्स्ट लाइन माइनर हैज टेकन कॉग्निजेंस ऑफ द लास्ट ओकेजन द टोटल वैल्यू ऑफ सेल इज ₹75 लाख, ₹50 लाख इज रिसीव्ड बाय श्री सो एंड सो। So माइनर हैज टेकन कॉग्निजेंस ऑफ 50 लाख रिसीव कर लिए। इसमें हम दिखाना चाह रहे थे रिन्यूअल के रिगार्डिंग में पेज नंबर 2 में नेक्स्ट पेज में आएगी है।
This is the agreement which you want to enforce.
Yes. Now, on the next page, page number 2. जब साथ में दिखाई गए तो मैंने एक चीज इसमें भी दिखा देना चाहते हैं आर्गुमेंट में कि पार्टी का नाम स्पेसिफिक है, सर्टेन है, लैंड्स का डिस्क्रिप्शन सर्टेन है। रिन्यूअल केस जो दिखाना चाह रहे थे सबसे लोएस्ट पैराग्राफ में माइनर विल फाइंड इन सेकंड लास्ट लाइन रिन्यूअल केस नंबर 46 47 का रेफरेंस आ गया। उसमें 46 भी ऑलरेडी वहां रिन्यूअल के लिए वहां रिकमेंडेड
Has been renewed also. एक का लिखा ही हुआ है, एक का renewed.
अब केवल बात कन्फाइंड आ गया।
Yes.
Now thereafter my lord will find that term and there is a specific term and condition also. So now it cannot be said that this agreement to sale is uncertain. केवल एक कंडीशन को मेरे my lord will have to assist my lord that with regard to consent of permission of the competent authority. Now, so far as consent of the permission of the competent authority, my lord of the last occasion, my lord had also. My lord, can you see a specific relief at section 13? Because that was dealt in 1970 Supreme Court also, and in 2010 similar I will show. Specific relief है section 30 13 Very. So this provision eviscerates the situation where in agreement to sale vendor had either no title, even no title, or even defective title. Rights of purchaser or lessee against person with no title or imperfect title. Where a person contract to sell or let certain immovable property having no title or only an imperfect. The purchaser or lessee, subject to the other provision of this chapter, has the following right. Purchaser का right क्या है? The vendor or lessor has subsequently to the contract acquired any interest in the property. The purchaser or lessee may compel him to make good the contract out of such interest. Now, second condition is my case, brother. So far as with regard to previous consent or permission is concerned, where the concurrence of other person is necessary for validating the title, and they are bound to concur at the request of the vendor or lessor, the purchaser or lessee may compel him to broker such concurrence. And when a conveyance by other person is necessary to validate the title, they are bound to convey at the request of the vendor or the lessor, the purchaser or the lessee may compel him to broker such conveyance. So this provision, my lord, gives ample power to the equity portfolio to direct the vendor to get the permission and to execute the registered settlement. Now, in this regard, my lord, 2010 Supreme Court, a very relevant decision, my lord.
You were referring to 1971.
71 दिखाई वो थोड़ा कंफ्यूजिंग था और पूरा फैक्ट्स ये बहुत अच्छा है इसमें
Citation ले दिए
है कॉपी
Copy. 2010
10 सुप्रीम कोर्ट की रिपोर्ट है
SAR
हाँ ऐसे है सुप्रीम कोर्ट की रिपोर्ट पेज नंबर 645 Now, in this case, my lord, what has happened, my lord? If my lord will say otherwise, when you read the facts. But in this case, my lord will find para 2, my lord. In this case, suit for specific performance was filed. Suit was decreed in part. And in para 2, my lord will find that when the decision of 70 Supreme Court was produced, in this case, the property of society was to be registered. And prior permission was necessary. So, my lord, we learn in the first appeal preferred by the plaintiff, the first appellate court, last line only to cut short the matter, it also directed the appellant to submit an application seeking permission from the competent authority and execute a registered sale deed in favor of the respondent. यही डिक्री अब चैलेंज हुआ अब हाई कोर्ट में सुप्रीम कोर्ट में ऑनरेबल अपेक्स कोर्ट ने 70 सुप्रीम कोर्ट को रिलाई करते हुए इसको इस जजमेंट को ऑफर किया। इसके पैराग्राफ 13 में ये मैटर ये डिस्कशन है सेक्शन 13 का और 70 सुप्रीम 70 सुप्रीम कोर्ट भी मैटर हम ले लेते हैं
You have it, no?
जी
आप भी
वो 71 है मैटर 70
अच्छा
एक और जजमेंट है ना, रीडिंग से मैंने दिखाया है, अपने हाई कोर्ट में है, माइनॉरिटी की न्यूज़ को देखने की जरूरत नहीं है। इसमें है कि अगर पेमेंट में ओवरमेंट है, उसके बाद नोटिस दिए हैं, एडवांस पेमेंट किए हैं, तो ना प्लेंटिफ फुलफिल्स द रिक्वायरमेंट फॉर सेक्शन 16C 1997 पटना पेंट के एक इम्पोर्टेंट फैक्टर चूक गया था माय लॉर्ड, टू असिस्ट माय लॉर्ड।
Yes.
Apart from this, one important fact I could not raise that point. Well, in this case, defendant number 3 appeared file application under order 7 to 11 CPC for rejection of my claim. The application was rejected. Can you take note of this matter? The order dated by order detail, order passed by the London Trial Court on 3/12/2019. The petition filed by the original defendant number 3 under order 7 to 11 was rejected. And thereafter the defendant number 3 did not take in opportunity to appear before the court to explain the
No WS was filed
WS was filed, it was not accepted.
after order 7 to 11.
ये prior to that क्योंकि कॉपी हमको सर्विस किया गया है मेरे रिपोर्ट में, सो मैं इसलिए मैंने बता दिया
But beyond time,
ये beyond time, beyond time. एविडेंस को लीड कर सकते थे,
क्या एविडेंस लीड कर
मतलब हम अगर
बिना
आप
रिटन स्टेटमेंट के
नहीं अगर वो आते तो ये सब चीज क्लियर हो जाता, और वो इसलिए नहीं आए इन ऑर्डर टू अवॉइड हिज लायबिलिटी। So my lord is well aware conduct of the parties. So my lord, on that count also, my lord, my suit was free to be defeated. और अनसर्टेनिटी का बात है तो अनसर्टेन तो कहीं है नहीं, केवल प्रीवियस परमिशन नहीं मिला उसके ग्राउंड पे माय लॉर्ड हैज ऑलरेडी टेकन नोट ऑफ द जजमेंट।
that is only ground for
ये होती उसे अनसर्टेनिटी माय लॉर्ड फॉर द लास्ट एजेंसी एक जजमेंट है नहीं मिल पाया उसका, लेकिन उसमें सुप्रीम कोर्ट में ये आर्गुमेंट हुआ सेक्शन 29 का, तो ऑनरेबल इसमें सुप्रीम कोर्ट ने कहा कि भाई फर्स्ट टाइम सेक्शन 29 का इंडियन कॉन्ट्रैक्ट था ये रेज नहीं किया जा सकता और यहाँ पे कहीं केस नहीं है स्टेट का कि अनसर्टेन है या एग्रीमेंट से भी क्लियर है कि अनसर्टेन है.
When the application was filed, it cannot be said to be uncertain.
Yes.
Whenever it is done, it will come because so far it has not been rejected.
Yes.
There is no order of rejection on
Yes,
the
yes.
policy. एक है maximum.
Deeply grateful. छोटा सा तुम लिख दिए.
ये पेज नंबर 53 16 to 2015 का क्या लेटर है ये वापस किया जाता है, ये क्यों वापस किया जाता है? अच्छा, ये उनको किसी और अथॉरिटी को एम्पावर कर दिया गया है.
सब्सिक्वेंट फैक्ट हम बात नहीं कर रहे हैं. लॉ में भी चेंज आ गया. पूरा कास्ट वन प्रॉपर्टी को भी होल्ड कराया जा सकता है. वो तो भी आर नॉट टेकिंग कि भाई डिसाइड हो जाए उसको बात है. जो एग्जिस्टिंग लॉ होगा उसके साथ.
तो आप तो रिन्यूअल होने के बाद योर स्टेटस वुड बी एज दैट ऑफ ए सबलेसी ओनली
सबलेसी. हां. और
because your right will be subservient to the right of the lessee.
उससे बियॉन्ड
उसको beyond तो नहीं होगा. उसका भी लीजहोल्ड राइट है तो आपका भी सबलेसी होगा.
एकदम. क्योंकि परपेचुअल लीज होता है. अगर परपेचुअल नहीं होता मतलब फॉर परमानेंट नहीं होता तो हमारे पास नहीं होता. लेकिन क्योंकि परपेचुअल खास लीज का होता है वो इसीलिए.
और मान लीजिए कि वो अगली बार रिन्यूअल का एप्लीकेशन ही ना दे तो
नहीं, इसीलिए तो एग्रीमेंट हो लगे.
38 में ना दे तो क्या हो? ऐसे पूछ रहे हैं.
हाँ, 38 में ना दे तो एप्लीकेशन ना दे तो रिन्यूअल कराना ही नहीं चाहिए. तब तक तो हम अगर मेरे फेवर में आ जाएगा तो हम करा देंगे.
कैसे करा लेंगे?
डिग्री अगर मेरे फेवर में आ जाएगा
वो तो स्पेसिफिक परफॉर्मेंस का आ जाएगा.
अगर वो
नहीं, स्पेसिफिक परफॉर्मेंस का क्या है?
अगर कोई पार्टी मान लीजिए माय लॉर्ड दिस क्वेश्चन माय लॉर्ड क्वेरी में कि अगर कोई पार्टी है लीसी है 38 या 40 में खत्म हो रहा है नहीं देता. अब अगर नहीं देता है तो रिन्यूअल नहीं होगा. अगर कोई पार्टी है प्रॉपर्टी के राइट पर है टाउन में प्रॉपर्टी है अब वो यहाँ नहीं चाहता है ना हम लोग यहाँ नहीं रहेंगे हम लोग तो जाएंगे विदेश यहाँ ऐसे ही छोड़ देंगे. तो जब जो होगा देखा
ट्रायल कोर्ट का जजमेंट थोड़ा देखते हैं.
जी.
Therefore, you want the court to pass a decree. State is also a party to decide the application for renewal because application for renewal has already been made. And subsequent to the decision on the application for renewal, the specific performance.
Yes.
उसके लिए हम उनको टाइम दें. इतना दिन में कर लीजिए.
तो डिग्री करना होगा. रिलीफ तो ग्रांट करनी पड़ेगा तभी सब आगे हो पाएगा नहीं तो नहीं हो पाएगा.
The state filed their written statement.
Yes, filed written statement, but no evidence has been.
Okay. What is your stand? What is the status of the renewal application?
We have mentioned that we are adverse para 9 that the variance statements made in para 2 with changes concerned, it is submitted that real body number 243 which pertains to the building and object that is 243 were renewed in the name of Ranjit Lahiri and Hardeep Lahiri for the period 1978 to 2008. The renewal of the building lease for the period 2008 to 2038 is under process. The order of the Deputy Secretary, the Department.
Yes, please.
The order of the Deputy Secretary, Department of Revenue and Land Reforms, Jharkhand, for renewal of orchard lease for the period 2008 to 2038 has been received, but the deed of lease has not been registered till now.
What about the other application?
It is under process.
कहाँ लिखे हैं under
In
process?
the same. The renewal filings of the building lease for the period 2008 to 2013
Is under process.
So, on the date of filing, as well as on the date of filing of the WS, both the deeds were not executed. It was not renewed.
No, on the date of filing, renewal with respect to one was granted.
No, it has been mentioned in the agreement, but it has not come.
No, that permission was already granted.
स्वीकृति दी जाए.
दी जाती है ना?
दी जाए
जाए.
subject to condition of payment of certain salami.
It's not a permission.
Challan has been deposited in order to show that the salam.
That challan has also been now with respect to page 90.
Abhijit Lahari had deposited. Abhijit Lahari is
वो
who?
तो वही है,
वही।
लेसी वही।
No document has been.
It has been exhibited.
No, it again refers. श्री अभिजीत लहरी, श्री रंजीत लहरी को प्रेषित करते हुए निर्देश दिया जाता है कि प्रश्नगत भूखंड के लिए लीज नवीकरण हेतु निर्धारित सलामी की राशि भू राजस्व प्राप्ति स्थित
नेक्स्ट पेज देखिए ना, नेक्स्ट पेज।
इसमें नहीं जजमेंट से पढ़ते
RTI application, the answer to RTI application has been exhibited as Exhibit 4. It consists of two enclosures. One is this letter, and other is with regard to deposit of salami of rupees 5,78,381. It has been deposited on 39/13. And with respect to the other lease renewal, it has been mentioned that the divisional commissioner has been empowered. Even if they allow the permission for renewal. Renewal of lease is one thing. Permission to transfer is another. Is there any permission to transfer?
In terms of last one, and the decision of the, I have one judgment of the WBC, I can right now say that so far as renewal is concerned, it is mere formality. We have to, lessee requires to file an application before the subsistence of the.
Which he has done.
Yes, done. And then.
What about?
So it is able to be their matter, even that our parent, I would say that these should be automatic. Once my application is submitted,
That's right.
renewal
Renewal is not an issue.
So far as
the point is permission.
So permission will fall under section 13. Now consent is mandatory. Now vendor will be directed to take consent in my name because there is always a name of prospective purchaser is there, and they will be directed to file an application for getting permission in my name. So that's why section 13 is there.
In your agreement, has anything been mentioned regarding application for permission?
ये है कि जितना पैसा होगा ना वो सब हम देंगे, वो है हम
वो तो आपने नहीं दिया।
नहीं हम तो जब वो
रिन्यूअल का तो परमिशन का तो आपने नहीं दिया रिन्यूअल का पैसा।
नहीं, अगर रिन्यूअल का नहीं देते तो रिन्यूअल होता नहीं, और रिन्यूअल जब भी होगा तो इवन आई अंडरटेक क्योंकि जो भी पैसा होगा जो भी होगा तो जो स्पेसिफिक परफॉर्मेंस होगा वो कॉन्ट्रैक्ट का होगा, टर्म हम पर बाइंडिंग होगा। जो भी कॉस्ट आएगा अगर मान लीजिए बढ़ भी जाए सेस कल होकर के जो भी होगा हम पर बाइंडिंग होगा, उसी कॉन्ट्रैक्ट के अनुसार हम बाइंड। कॉन्ट्रैक्ट के बियॉन्ड हम भी नहीं जा सकते। रियल प्रैक्टिस यही है, मतलब एप्लीकेशन जब भी फाइल होगा वैसे फाइल करेंगे या तो पावर ऑफ अटॉर्नी देंगे और सब चीज परसू करेंगे, लेकिन जब भी होगा परमिशन का भी या जो भी होगा वो तो इन द नेम ऑफ वेंडर ही होगा। हम उसको सब परसू करेंगे, जो भी लॉ कहेगा, जो भी पैसा अगर एग्जॉर्बिटेंट भी होगा तो वी विल हैव टू पे, क्योंकि पहले के टर्म में आज के डेट में सलामी में बहुत अंतर है।
सेकेंड पार्टी कौन है, आप या फर्स्ट पार्टी?
हम सेकेंड clause में अगर असिस्ट करना है तो clause number 2 है मतलब that the second party shall bear all the funds, clause number 2 shall bear all the funds required for transferring the property to second party, including these premium of the first party, for obtaining permission from a government stipulated authority to sell half share of the first party to the second party। जो भी खर्च आएगा वो हम बेयर करेंगे। ये हमको एप्लीकेशन लिख करके वो एप्लीकेशन सबमिट करेंगे या पावर ऑफ अटॉर्नी देंगे, हम उसको परसू करके जो जब रिक्वायरमेंट होगा डिपॉजिट का हम डिपॉजिट करेंगे।
It is the duty of the second party to pursue with the task involved in the lease renewal process.
हाँ,
What have you done to this?
तो ये परमिशन के लिए अप्लाई करेंगे, इसे रिन्यूअल के लिए तो इसलिए हम डेट में भी दिखाए थे कि सब कुछ हो गया और वहाँ पेंडिंग है, और परमिशन के लिए जब वहाँ रिन्यूअल हो जाएगा इसके बाद ये एक एप्लीकेशन हम लोग क्लॉज भी है इसमें, मैं करना हूँ इसको निकाल क्लॉज भी है, इसे इसे एक एग्रीमेंट क्लॉज है, क्लॉज नंबर 5 है। Second party will get the renewal done and pursue the matter of taking permission for sale, for which that's important. The first party will hand over all necessary applications under his signature to the second party and will appear in person if तो वो एप्लीकेशन दे देंगे, लिख करके दे देंगे या पावर ऑफ अटॉर्नी दे देंगे, उसके बाद जब रिक्वायरमेंट होगा उनको आना होगा, ये सब उनको करना होगा।
The private party is not appearing. You are for whom? State first. Private party को notice सब हो गया था।
Notification हो गया था, paper publication में मतलब continuously 3 months we have waited, which was running in the list, their date was fixed, and thereafter my lord has fixed this case.
What do you have to say? आपने judgment नहीं पढ़ा, judgment।
पढ़ेंगे my lord को, ये जब हो गया ना तो my lord
Ready and willingness पे क्या फाइंडिंग? ये तो readiness and willingness पे तो फाइंडिंग होना ही होगा ना।
उसमें वही आया कि परमिशन का कोई डॉक्यूमेंट नहीं लाया है, जो my lord has taken out of it, तो बोले थे कि उसके बाद लेके चले गए वो उस पे कि ये अनसर्टेन दिखा देंगे। हमारा इंटरनल पे क्योंकि बाकी में वो सब रिवीजन और डिस्कशन किया गया है, और जो फाइलिंग स्टार्ट होता है ये रिलेवेंट है। पेज नंबर 15 से।
Yes, and their application.
In this suit, the plaintiff has contended that he was ready and willing to perform his part of contract. In this regard, firstly, I would go through the willingness of the conduct of the plaintiff, that the agreement of sale was executed between both the parties on 17/12/2014, and for non-execution of the said agreement, plaintiff sent the legal notice to defendant number 3 to 3C on 29/7/2016 and defendant number 1 on such and such under section 80 CPC. If after perusal of both legal notices, it appears that both notices were sent to the defendant after a lapse of approx 2 years from the date of agreement to sale, and I think this conduct is not shows the willingness of the plaintiff to purchase the suit land. However, in order to subsequently his claim for readiness, the plaintiff has produced the bank statement which was marked as exhibit number 3 to 3/4, stated by the plaintiff that he was ready to perform the duty and consideration amount was in his account. After perusal of the said bank statement, exhibit number 3 dated such and such, exhibit number 3/1, 3/2, 3/3, 14, it appears that all the said accounts is in the name of plaintiff Mohammed Tiwari. On all the statements are on or before the date of agreement of sale, dated 17/12/2014. Further, after perusal of exhibit number 3/4, bank statement dated 3/10/2015 to 16/5/2017, it is found that this statement is in the name of Mahalakshmi Vidcom Private Limited and not in the name of the plaintiff. In this regard, there are two issues to evident that the plaintiff is proprietor of the said firm, and if the said firm is to enter the agreement for sale dated 17/12/2017. For the first issue, there is no any documented evidence came on the record that the plaintiff is the proprietor of the said firm, and secondly, the presumption that the plaintiff is proprietor of the said firm. The agreement dated 17/12/2014 was executed in persona between the plaintiff and the Mahavir Tiwari, and not on behalf of the firm, namely Mahalakshmi Vidcom Private Limited, and the amount of the said firm cannot be considered as plaintiff's fund. Further, plaintiff could not satisfy that to be true that why the plaintiff has produced the bank statement which is in the name. Before the agreement of sale dated 17/12/2014 and after the date of agreement dated 17/12/2014, he has produced the bank statement of Mahalakshmi Vidcom Private Limited. Therefore, it was the duty of the plaintiff to approach the defendant having prepared for the execution of the sale deed in the respect of the suit property. There has been no evidence available on the record which may go on to suggest that the plaintiff took any step in furtherance.
You see, there is also a finding that there is nothing on record to show that the plaintiff is the proprietor of the state firm.
Proprietor, my lord, just I submit, my lord, 50 lakhs payment was proved. So far as 50 lakhs check of plaintiff was proved in the agreement, exhibit 0/0. Now the only a meager amount was there, remaining one, only meager amount.
No, it is another thing. That is a separate argument.
Now,
You showed your availability of fund on the
Yes.
basis of statement of account.
yes, along with that, man, I am just showing one thing. Just showing.
Statement in the name of Mahalakshmi
उसके
Vidcom
साथ
Private.
माँ विधवाओं के साथ ये जो मेरा एविडेंस हुआ मैडम, जो एग्जामिनेशन इन चीफ है, उसमें मैंने बोला कि मेरा फर्म है और उसके साथ एक सर्टिफिकेट अनेक्स है जो बैंक स्टेटमेंट के साथ है, जिसमें 3 डायरेक्टर को दिखाए गए हैं और एक जो डायरेक्टर है वही ये एविडेंस में आया है, ओरल एविडेंस में।
It is required not only to be pleaded, pleading and proof दोनों होना चाहिए.
हाँ, प्लीडिंग प्रूफ होना चाहिए, ये ठीक है, लेकिन एविडेंस के बाद जहाँ तक है रिमेनिंग के 50 से 65 तक के लिए तो प्रूफ है।
वो तो प्रूफ है.
हाँ, वो
आपका
तो-
कहना है उसमें कोई डिस्प्यूट ही नहीं है क्योंकि एग्रीमेंट में लिखा है.
तो अगर मतलब from a prudent person just thinking मैडम, if a person can pay 65 lakh, he will not pay the remaining legal amount of about 9 or 8 or 9
Subject to availability.
subject to.
So in order to prove the availability of
If
fund,
that is the case, मैडम, one judgment is also मैडम, उसमें है, उसमें हम दिखा रहे हैं, एक मेरे पास है, एक इसको देखा जाए, अगर लिया जाए वादी संख्या PW रिकॉर्ड से निकाला जाए, PW1 का एग्जामिनेशन इन चीफ, इसमें बैंक स्टेटमेंट के साथ जो हम लोग जो एग्जीबिट कराए, ये है, ये रिकॉर्ड में देखा जाए, इसमें है
एग्जिबिट
पैराग्राफ,
नंबर
ये एग्जिबिट नंबर 3/4 है, लेकिन इसके साथ जो सर्टिफिकेट अनेक्स है ये डेटेड है 31/1/2023। मैं महावीर तिवारी इसका
डिपेंडेंट कौन है इसमें?
डिपेंडेंट नंबर 3 है रंजीत लाहिरी,
प्लेंटिफ का क्या नाम है?
महावीर तिवारी।
पावर ऑफ अटॉर्नी होल्डर
कौन?
महावीर तिवारी।
नहीं सेकंड पार्टी देखा है डिवीजन 1 by 1 जो पेज नंबर 2 था ना, पेज नंबर 2
ये जो डॉक्यूमेंट के साथ
दिखा
जो
है।
एक सेकंड,
एक बार देख
ये
लीजिए।
जो बैंक स्टेटमेंट के साथ जो डॉक्यूमेंट लगा हुआ है,
हाँ।
इट शोस महावीर तिवारी एज अ पावर ऑफ अटॉर्नी।
देख महावीर तिवारी इज ऑथराइज्ड सिग्नेचरी फॉर बैंक अकाउंट नंबर सच एंड सच।
नो नो, पावर ऑफ अटॉर्नी धारण करने वाले का हस्ताक्षर।
कहां पे?
दिखाइए हमको सर।
तो फॉर दैट काइंडली सी एग्जिबिट 1 by 1 पार्टी का नाम में जो एग्रीमेंट हुआ है वो महावीर तिवारी, सेकंड पेज। भाई तो निबंधन प्रमाण पत्र है महालक्ष्मी की दुकान,
उसका बीच में लिखिए ना क्या?
ये तो है श्रेणी, ये पावर ऑफ
Then
अटॉर्नी।
पावर ऑफ अटॉर्नी।
हाँ तो पावर ऑफ अटॉर्नी था मतलब इसका ना लक्ष्मी बिल दुकान।
हाँ, लक्ष्मी
लक्ष्मी
बिल
बिल-
लक्ष्मी बिलकौन का। तो
हाँ।
आपका प्रोप्राइटरशिप फॉर्म कैसे हो जाएगा?
प्रोप्राइटरशिप नहीं, प्राइवेट लिमिटेड फंड है ये।
अरे भाई, ये आपका प्रोप्राइटरशिप फॉर्म कैसे हो
इसके
जाएगा?
बाद वाला नहीं, हम दिखा देते हैं आपको। मैं ग्रेटली ग्रेटफुल टू दिस बोर्ड। कैन यू टेक नेक्स्ट पेज?
तो आपके पास
मैं ग्रेटफुल।
इसमें क्या है?
ये देखते मतलब being counsel I always conceive मतलब this honorable court always मतलब encourage the like we juniors।
आप जूनियर थोड़ी हैं।
हम तो जूनियर बोल रहे हैं
But
मतलब in that मतलब
list of directors.
yes
This is a company.
हाँ company
Yes, it is not a proprietorship.
not a proprietor that's I stand corrected madam।
It is not a
not a
proprietorship.
proprietor yes
तो company is not the purchaser of the property.
नहीं है
तो इसका बैंक अकाउंट देके आप क्या प्रूव करना
कोई
चाहते हैं?
नहीं कर रहे हैं। ये हम ये दिखा रहे थे कि ये वन ऑफ द डायरेक्टर बस ये प्राइवेट लिमिटेड
He has got no business.
नो बिजनेस लेकिन ये इससे जो कनेक्शन वाला जो बात है
ये कनेक्शन आपने डायरेक्ट आपने अपने फॉर्म से ये जो आपका जो फॉर्म है इससे आपने पेमेंट कर दिया, ठीक है ना? आपने बीइंग द पावर ऑफ अटॉर्नी आपने पेमेंट तो कर दिया, बट इनका स्टेटमेंट ऑफ अकाउंट दिखाकर आप कैसे ये साबित कर सकते हैं दैट
वो नहीं
द फंड इज अवेलेबल?
नहीं वो नहीं दे सकते हैं। वो हम ये कहते हैं क्योंकि वो तो कंपनी का सेपरेट फंड उस पर नहीं हम तो ये दिखा रहे हैं कि ये इसमें डायरेक्टर
ठीक है, डायरेक्टर इट मेक्स नो डिफरेंस।
तो कोई डिफरेंस नहीं तो
Where is your readiness and willingness?
minor readiness and willingness is concerned minor
Readiness दिखाइए, willingness मत। Readiness.
readiness तो minor if we were we complied our own all part minor
Readiness to pay the balance consideration. In order to show your readiness to pay the balance consideration, you had put the statement of account of the bank, of this company.
now minor for that
And it appears that you
Yes,
asserted that it is your
yes.
form.
So far as my submission one thing minor since it is equity course minor if I will not be able then minor it is beyond imagination minor a person can pay 65 lakh
I can imagine.
then if my lord can imagine then my lord kindly
10 lakhs कोई छोटा अमाउंट नहीं है ना for Jharkhand.
जो 65 लाख जमा कर दिया उसके लिए 10 लाख होता है
नहीं, 65 लाख तो जमा
अगर
किया,
मेरे पास
उसमें
650 रुपया
से
जमा-
कुछ पैसा कंपनी
नहीं
का,
my lord
उसमें से भी कुछ पैसा कंपनी का जमा किया।
वो कहाँ कैसे की
नहीं किया
ना
ये महालक्ष्मी will
ना 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 उसका नहीं, वो तो एग्रीमेंट अलग बैंक स्टेटमेंट है, वो तो आप देखी है।
so all the payment was made from your account,
Yes, yes,
personal account.
yes, my lord.
So
my lord
in
has
order
taken
to
pay.
in order to show
Yes.
that the fund is available with you, why did you at all file the statement
ये
of
बात
Mahalakshmi?
इसलिए my lord सुप्रीम कोर्ट इस पॉइंट को कंसीडर किया कि परचेजर का बैलेंस कंसीडरेशन कुछ बच गया, तो क्या परचेजर को पहले सारा पैसा रेडी करके रखना होगा, वो रेडी हो या ना हो? सुप्रीम कोर्ट
You
से
see, had you not exhibited this document, it means that you say that the remaining amount is available in the company.
हाँ वो यही दिखाने के पर्पस से,
ये दिखाने का
यही दिखाने के पर्पस
कंपनी से पैसा आएगा।
समटाइम्स मतलब ट्रायल कोर्ट में हम लोग जो करते हैं उसको हम टू वेरी फेयर मतलब इसलिए वो दिखाया कि ये इसको पर्पस के लिए ये इन्होंने लाया, लेकिन अप टू 65 लाख ये था और सुप्रीम कोर्ट ने उस केस में मतलब 70 सुप्रीम कोर्ट ने बोला कि अगर जो बैलेंस जो अमाउंट है वो उसके लिए टू प्रूव हिमसेल्फ रेडी एंड विलिंग एज ए परचेजर हैज नॉट नेसेसरीली टू प्रोड्यूस द मनी और टू वाउच अ कंक्लूडिंग स्कीम फॉर फाइनेंसिंग द ट्रांजैक्शन। सुप्रीम कोर्ट ने 70 इसी बात को लेकर कि हम
So 70 में कहाँ है अब 2021, 22, 23, 24, 25 एक केस थोड़ी है रेडीनेस एंड विलिंगनेस पर, लाइन लगा हुआ है रेडीनेस एंड विलिंगनेस।
रेडीनेस अगर तो हम तो नोटिस में देके कहे ना, उस नोटिस में एग्जीक्यूट हुआ, हम बोले कि मेरे पास पैसा है आइए आप हमको कर दीजिए।
पैसा का सोर्स तो आपने बताया कहाँ है पैसा,
सोर्स बताना है कि पैसा देना।
सोर्स भी तो जब आप रेडीनेस अपना दिखा रहे हैं और रेडीनेस में आप किसी और का बैंक अकाउंट स्टेटमेंट लगा दे रहे हैं तो इसका क्या मतलब हम समझ
और कि हम बोरो कर सकते
और बोरो
नहीं कर सकते बोरो
भी डू नॉट
मतलब
हम बोरो करेंगे कि टाका डालिए
इक्विटी कोर्ट मतलब I understand my lord I can understand being equity court I am arguing that a person purchaser who has paid 65 lakhs he can borrow any amount from any person. And so far as the in order to prove whether I am relying upon there are 6 or 70 Supreme Court एक छोटा सा अमाउंट अगर बचा रहेगा अगर उसी पर रुक जाए केस खत्म हो जाएगा। हम कुछ
छोटा सा अमाउंट नहीं है, कितना परसेंट हुआ परसेंटेज में बताइए।
अबाउट 10%
10% नहीं, इट इज 15%।
मतलब
76 में 10 लाख
8 लाख रुपए तो कैश भी दिया ना मैडम।
टोटल आपने कितना पेमेंट कर
टोटल 58 लाख कर दी,
58 लाख कर दिया,
कर दिए।
76 माइनस 58 कितना होता
75 माइनस 58
16 lakhs
60
is due,
is the
correct? How much percentage does it
उसमें
cost?
15 लाख का वो है चेक है उसके पास
चेक से क्या होगा? चेक is of no use, it is not a
वो जो
सिक्योरिटी चेक है, इसका क्या रेलेवेंस है?
सिक्योरिटी चेक का
कोई रेलेवेंस नहीं है। It cannot be said, it cannot be counted for your readiness। हम बता तो रहे हैं 10 करोड़ बताइए 50 करोड़ का चेक देते हैं, कोई किसी को दे दे 50 करोड़ का चेक, इसका क्या वैल्यू है? भाई देता है चाहे नहीं देता, लेकिन देने में कोई बार नहीं है। Issuance of check will not be an assumption that there is balance in the account.
It will be a presumption, my lord.
No presumption.
Liability, legal.
Liability है,
Legal के
liability है, availability नहीं।
हाँ, वो तो है, वो तो legal।
Availability नहीं है, liability है। Presumption of liability, availability नहीं।
Availability। लेकिन
And you have to show readiness and willingness.
लेकिन readiness and willingness में मतलब I must accept मतलब the plaintiff has to prove from the evidence from the legal notice. He said in the legal
16 by 76 कितना होता है बताइए? 16 by 76. लगभग 20% आपका ड्यू है। मीगर अमाउंट नहीं बोल सकते हैं, इट इज नॉट ए मीगर अमाउंट।
80% is paid.
80%, 20% आपका ड्यू है।
80% is paid.
इट इज एक्सेप्टेड, 20% आपका ड्यू है। ये कोई मीगर अमाउंट नहीं। Amount not only in terms of lakhs, amount in terms of percentage is also not meager.
Now, my lord, for that, my lord, I must submit, my lord, that in the legal notice, my lord, I have specifically stated that I am ready with the balance consideration amount. And can we see, my lord, can we see that the agreement
How many persons have deposed?
2%.
Evidence but पहले इश्यूज देखते हैं क्या क्या करना है. कम से कम 10 जजमेंट तो हम ही किए हैं रेडिनेस एंड विलिंगनेस. Not less than 10 judgments I have passed on readiness and willingness.
Lekin my lord will find, my lord, in 2 judgment I have gone through, my lord, and in 2 judgment my lord will find that amount which was paid to the by the purchaser to the vendor. Not a single case, my lord, will find that 80% amount was paid by the purchaser. 80% amount was paid by the purchaser.
एक में हम 50% में रिजेक्ट करते हैं by taking the percentage. आपने सारे जजमेंट्स
नहीं पढ़े. एक बार आप देख लेते हैं.
मैं देखना उससे परसेंटेज.
नहीं, तो
मेरा ये मतलब ये है इट इज नॉट अ मीगर अमाउंट.
हाँ वो तो
In terms of percentage.
In terms of percentage.
ठीक है.
Yes, I agree.
In terms of percentage, it is a substantial amount which is remaining to.
Yes. वो तो yes, I agree. I go down. I go down.
Evidence पढ़ी. Evidence पढ़ी है. ये कमर्शियल कोर्ट में नहीं फाइल हुआ था.
नहीं.
गवाही पढ़ी गवाही.
Para 17 of evidence of plaintiff. Examination in chief on 22/11/2022.
पैरा नंबर 7 पर. पैरा 7. इस प्रकार मैंने प्रतिवादी को अब तक 50 लाख रुपए का भुगतान किया. आगे
यह की प्रतिवादी संख्या 3 को 50 लाख रुपया भुगतान करने के बाद एक न्याय इकरारनामा मेरे और प्रतिवादी संख्या 3 के बीच दिनांक 17/12/2014 को निष्पादित किया गया, जिसमें प्रतिफल राशि पहले से तय राशि 76 लाख रुपये से 1 लाख रुपया कम करके 75 लाख रुपये तय की गई। यही वह इकरारनामा है, इसे प्रदत्त करें। 17/12/2014 को एक इकरारनामा निष्पादित होने के पहले प्रतिवादी संख्या 3 को मेरे द्वारा 8 लाख रुपया गैलेरी होटल में नकद दी गई, जिसके बाद में सुरक्षा की दृष्टि से चेक जिसका संख्या नंबर सचन से रुपये 15 लाख रुपये का चेक मेरे द्वारा प्रतिवादी संख्या 3 को दिया। 8 लाख रुपया कन्हरी में नकद दी और 15 लाख रुपये का चेक प्रतिवादी संख्या 3 को दिया गया और कहा कि पावर ऑफ अटॉर्नी मेरे नाम पर पंजीकृत करने के उपरांत मेरे द्वारा दिए गए चेक की मार्फत बैंक से रुपये निकाले गए।
So he wanted that power of attorney should be executed.
यह की बात भूमि रंजीत लहरी व उसके भाई अभिजीत लहरी के नाम पे पंजीकृत है, जो कि अभी खास कार्यालय में 10/4/2008 से 31/3/2038 नवीकरण हेतु लंबित है। प्रतिवादी संख्या 3 ने मुझे कहा कि नवीकरण हेतु लंबित है, इसलिए पावर ऑफ अटॉर्नी की बात का जिक्र नहीं करें, पहले नवीकरण होने दें। यह कि इकरारनामा की शर्तों के मुताबिक मैंने वाद भूमि को खास मान भूमि को पूरा खर्च का वहन करके भूमि को 2038 तक का नवीकरण करवा दिया। प्रतिवादी संख्या 3 एवं उसके भाई अभिजीत लहरी के नाम पर तथा इस बात से उन्हें अवगत भी करवा दिया, यह कि मेरे द्वारा भूमि नवीकरण के पश्चात मैंने वादी को बाकी बचा 17 लाख रुपया लेकर वादी भूमि का आधा हिस्सा मेरे नाम पर हस्तांतरित करने को कहा। यह कि भूमि को मेरे नाम से
वाद भूमि को
हाँ, यह कि मेरे वाद भूमि को मेरे नाम से कहने पर प्रतिवादी द्वारा यह कहने लगे कि यह भूमि की कीमत काफी बढ़ गई है, अब यह भूमि नई कीमत पर लेनी होगी। यह कि दिनांक 25/6/2016 को मैंने देखा कि वाद भूमि को कुछ अनजान लोग प्रवेश कर कार्य कर रहे हैं।
refusal for performance. Paragraph.
Yes, contrary to the
This is refusal for performance. इसका कोई डेट नहीं।
यह कि दिनांक 25/6/2016 को मैंने देखा कि वाद भूमि पर कुछ अनजान लोग प्रवेश कर कुछ कार्य कर रहे हैं। मेरे द्वारा पूछने पर वे लोग बताए कि प्रतिवादी संख्या 3 के द्वारा उन्हें भेजा गया है। जब मैंने प्रतिवादी संख्या 3 से इसके बारे में पूछा तो किसी भी तरह का संतोषजनक बात नहीं कही गई। यह कि पुनः मैंने प्रतिवादी संख्या 3 से उक्त विषय में बात किया, परंतु प्रतिवादी संख्या 3 के द्वारा किसी भी तरह का संतोषजनक मुझे जवाब नहीं दिया गया। जब वाद भूमि पर कुछ अनजान लोग कार्य करने लगे और भूमि पर उनके झाड़ी को हटाने लगे, तब मैंने उनसे पूछा, उन्होंने जवाब दिया कि यह भूमि श्री बालेश्वर प्रसाद महतो द्वारा खरीद लिया गया। हम उनके आदेश पर यह कार्य कर रहे हैं। यह कि प्रतिवादी संख्या 3 के मेरे बीच हुई इकरारनामे को प्रतिवादी संख्या 3 नकार दिए एवं तय की गई रकम से ज्यादा की मांग प्रतिवादी संख्या 3 के द्वारा की जाने लगी। यह कि मैंने प्रतिवादी संख्या 3 को कुल 58 लाख रुपया भुगतान कर दिया एवं शेष राशि देकर वाद भूमि हस्तांतरित करने हेतु कई दफा प्रार्थना किया, परंतु प्रतिवादी संख्या 3 के द्वारा मेरे प्रार्थना को ठुकरा दिया गया। मैं आज भी भूमि को खरीदने तैयार हूँ तथा बची हुई राशि विपक्षी संख्या 3 एवं 3A को देने को तैयार हूँ।
Just pause for a moment. After the कई दफा प्रार्थना की है, लेकिन ये तैयार नहीं। आगे
मैं आज भी भूमि को खरीदने को तैयार हूँ तथा बची हुई राशि विपक्षी संख्या 3 एवं 3A को देने को तैयार हूँ। हो गया था तो यह कि प्रतिवादी संख्या 3 मुझसे बात नहीं करने लगे, जिसके बाद मैंने 29/7/2016 को स्पीड पोस्ट के माध्यम से अपने अधिवक्ता के द्वारा वकालतन नोटिस प्रतिवादी संख्या 3 को भेजा, जिसमें इकरारनामा जो कि दिनांक 1 को निष्पादित हुआ था, तो इकरारनामा में तय शर्तों के मुताबिक वाद भूमि मेरे नाम करने की बात कही। प्रतिवादी संख्या 3 के द्वारा किसी भी तरह का कोई जवाब नहीं दिया गया, यही वह नोटिस में था। यह कि मैंने इसकी सूचना उपायुक्त हजारीबाग शासमान अधिकारी को भी दिया, परंतु कोई कदम नहीं उठाया गया। अंतिम में प्रतिवादी संख्या 3 के द्वारा मेरे साथ धोखाधड़ी करने के खिलाफ मैंने मुख्य न्यायिक दंडाधिकारी हजारीबाग के समक्ष आपराधिक मुकदमा दर्ज कराया गया। यह कि तत्पश्चात मैं अपने नियोक्ता से मिलकर यह बात बनवाकर न्यायालय के समक्ष उचित न्याय की बात आया।
इसके बाद आपका क्रॉस एग्जामिनेशन हुआ 22 तारीख को।
जी
पढ़ी। और उसके बाद आपने फिर से दोबारा भी फाइल की। नहीं, ये जो आपने यहाँ पर बोले ना कि रेडी एंड बिलिंग है, उसके बाद आपने यहाँ पर एग्जिबिट सब मार्क किया। एग्जिबिट 1 by 1 this has been marked later on. When and how these exhibit 3 by 1, these bank accounts were marked? When were they marked?
ये मार्क हुआ है ये उन्हीं के एग्जामिनेशन चीफ
कहाँ?
27/1/2023 का है।
बाद में और भी बात हुई।
जी
एक बार 23/1/2023 को आपने एक एफिडेविट फाइल किया, इसमें आपने कुछ डॉक्यूमेंट्स मार्क किया, ठीक है? उस पर आप कई बार एग्जामिन हुए हैं क्या? क्रॉस एग्जामिनेशन के बाद भी एग्जामिनेशन इन चीफ आपका चला है?
उसके बाद एक डिलीट हुआ है।
कैसे?
रिकॉल हुआ होगा क्योंकि डिलीट हुआ 11/20 फाइल और
ऑर्डर होगा ना रिकॉल का?
इलेक्टिव एग्जीक्यूटेड डॉक्यूमेंट वो है टेकन नोट ऑफ दी
मस्ट हैव, बट आपका बार-बार एविडेंस हो रहा है, रिपीटेड एविडेंस है। प्रतिवादी अपना नो ऑब्जेक्शन देते जा रहे हैं, प्रोसीडिंग इज एक्सपर्ट। और ये जो पार्टिसिपेट करते हैं वो आपका नो ऑब्जेक्शन देते जा रहे हैं ऑन द एग्जिबिट्स। ये प्रोसीजर सही है। बैंक स्टेटमेंट नहीं, बार बार आपका एविडेंस आना और बार बार आपका गवाही होना। पावर है तो रिकॉल करके ना, पावर है। ऐसे कैसे होगा कि क्रॉस एग्जामिनेशन हो गया उसके बाद आप फिर गवाही देते जा रहे हैं? एंडलेस ही हो गया ना, 3 बार हो गया।
क्योंकि डॉक्यूमेंट उसके बाद तो नहीं दिए, मतलब वो 2 बार, टोटल 3 बार हो गया। उसके जो डॉक्यूमेंट छूटा था वो तो जो है सो हम उसको इंप्रूव नहीं कर सकते, लेकिन एग्जीबिट्स क्योंकि मटेरियल अभी एडमिटेड डॉक्टर अभी एडमिटेड आई मस्ट नॉट से कि जो
you were discharged on 7/12/22।
क्योंकि मटेरियल डॉक्यूमेंट्स था तो वो ट्रायल कोर्ट टेकिंग अ व्यू कि भाई इट शुड बी डिसाइडेड ऑन मेरिट।
No, therefore you see when a proceeding is expert, अगर मान लीजिए वो appear हो रहे हैं ना, consent से कुछ भी मार्क हो रहा है कोई दिक्कत नहीं, When the proceeding is ex parte, so this is not.
एफआईआर एक्स पार्टी भी करना मुश्किल है, ये तो दिए, ये तो दिए, 711 के पिटीशन तो दिए।
The proceeding was set ex parte against them.
हाँ तो कब जब वो आना छोड़ दिए तो
हाँ ठीक है, ex parte हो गया था ना proceeding. The proceeding was ex parte. The witness was discharged, and thereafter he came time and again.
Since my lord only in order to do so, there is certainly there is delay, not like
It's not a matter of delay.
But my lord only in order to make substantial justice, the London trial court exercising the power under order 1817, my lord, permitted and that has been limited, my lord. The London trial court has taken note of accepted these exhibits. Had it been the case that no, these exhibits are not in accordance with law, my lord, then matter would have been known. Delay तो है, उसमें I will not say कि there is no delay. There is a delay. लेकिन जो भी कुछ हुआ वो during pendency of suit.
The Tiwari का no objection and it is taken on record. Tiwari में no objection पे चल रहा है. पढ़िए आप अपना बाकी का जो आपका गवाही है उसका पढ़िए एग्जिबिट ये वाला एग्जिबिट एविडेंस ऑन 27/1/2023
Yeah, 27 one. मैं इस दबाव संख्या 114-16 का वादी हूँ यह कि मेरे द्वारा दिनांक 16/1/2023 को एक स्टेट बैंक ऑफ इंडिया का 3/4/2013 को 8 लाख रुपये और 9 लाख रुपये का प्रतिवादी लेखा लेरी को मेरे बैंक खाता नंबर इतना से दिया है जिस पर मेरे ब्रांच मैनेजर श्री मनीष मोहन के द्वारा साइन कराया हूँ तथा मोहर लगाकर सत्यापित कराया हूँ जिसे मैं पहचानता हूँ तो 10-3 अंकित किया जाए यह कि बैंक स्टेटमेंट बैंक ऑफ इंडिया हजारीबाग जिसका खाता संख्या सच है इंडिया विनोबा भावे यूनिवर्सिटी ब्रांच से लिया हूँ जिसमें 2/4/2013 को अजीत लहरी से मुझे 8 लाख रुपये लिया तथा दिनांक 4/5/2013 को लेखा लहरी ने 4+4 8 लाख रुपये प्राप्त की जिसका मैंने मैनेजर
आप इसमें आए जस्ट हम देख वो तो जो पेमेंट है उसका डिटेल है एक आप 31/1/2023 को भी एग्रीमेंट सर, पैरा 6 को पैरा 6
अच्छा हाँ, बचे हुए
यह कि बचे हुए राशि वादी निबंधन के समय
बच्चे संख्या 3 को देना था, वादी के पास उस समय उनके खाते में पर्याप्त पैसे थे जिसका प्रमाण उनके पर भी तो हम शुरू में कह दिए थे।
नहीं, ये this is the evidence that at the time of agreement the money was available and the availability of money was with the company.
नहीं
फिर
ये
क्या?
नहीं ना,
ये पढ़िए इसको पैरा 6
ये इसको देखने के बाद
6 को पढ़िए, 6 को पढ़िए ना।
6 है किसी इन रिलेशन टू एग्जीक्यूट 3/4
नहीं, आप 6 से पढ़ रहे हैं।
पढ़ 6 पढ़
पढ़िए।
ये वो नहीं है, यह कि बचे हुए राशि मतलब आई देखो
हाँ।
बचे हुए राशि वादी निबंधन के समय
हाँ
सो दिस वाज टू बी निबंधन के समय
हाँ
में विपक्षी संख्या 3 को देना था,
हाँ।
वादी के समय उस समय उनके खाते में पर्याप्त
वादी के पास उस समय,
हाँ वादी के पास
निबंधन तो पहले नहीं हुआ ना।
देना था।
हाँ देना था।
May say one thing. Sometimes, being a lawyer, I can commit some fault. But the totality is that this was in relation to exhibit by 3/4. उनके फल मार्क बिल को हमें तो एक्सेप्ट भी किए, प्राइवेट लिमिटेड कंपनी है उसके कंपनी से नहीं खाया जा सकता है, लेकिन जिसके वादी के द्वारा अपनी फर्म का बैंक स्टेटमेंट न्यायालय में दाखिल कर रहा हूँ जो इससे इस बात को प्रमाणित करता है कि उनके खाते में उस समय पर्याप्त राशि उपलब्ध था, यही वो बैंक का स्टेटमेंट है जिसे मैं
एग्जिबिट 3/4 देख लेते हैं। आपने क्या दाखिल किया?
वो बिल कौन का ये है मतलब
नहीं पढ़िए ना, क्या स्टेटमेंट ऑफ अकाउंट और कब का स्टेटमेंट ऑफ
वो
अकाउंट?
बैंक वो कंपनी का है, हम उसमें नहीं
कब का?
वो है इसके बाद का
कब का बताइए।
वो हम नहीं आर्ग्यू करेंगे, मतलब बियॉन्ड आर्ग्यू बाय आई विल डू दी राइट टू डू दी केस, बट आई विल नॉट आर्ग्यू बियॉन्ड दी केस। कैन यू सी द जजमेंट पर लिस्ट ऑफ एक्टिविटीज गिवन मतलब पेज नंबर 11 सीरियल नंबर 9 देखा जाए एक्टिविटी बैंक स्टेटमेंट डेटेड 30/10/15 टू 16/5/2017 ये एक्टिविटी नंबर 3/4 इंटरनल पेज 11 पे while not I will always like to do the case never say not any false thing बैंक स्टेटमेंट डेटेड 30/10/15 टू 16/5/2017 एक सीरियल नंबर 9 में हम इंटरनल पेज में पैराग्राफ 9 में डॉक्यूमेंट्री एविडेंस है 1 2 3 4 5 6 7 8 9
एग्जिबिट 3/2
3/4 लिखा हुआ है
3/2
3/2 है उनका बैंक स्टेटमेंट 3/4 सीरियल नंबर 9 में लिखा हुआ है
पे एग्जिबिट 3/4 का मार्किंग किया है। एग्जिबिट 3/4 से मार्किंग
जो पहला एंट्री है जो 4/11/2015 का है देखा जाए बाएं साइड में पहला जो एंट्री और ऊपर भी लिखा हुआ है रिपोर्ट फॉर द पीरियड 30/10/2015 से 16/5/2017
अकाउंट ओपनिंग बैलेंस आपका 11,000 कितना से शुरू हो रहा है इससे कम ये है ना ये अकाउंट ये है
जी
ना?
जी जी ये बदला है ये सेट में 4/11/2017
1 So this is what you have to say on readiness and willingness. आपको क्या बोलना?
State for the release and all part. I'm telling you 242 and 243 are the documents. 242 was still under process. 243 Salami was deposited. In both the cases, the lease was not executed. Now the case has been filed for specific performance of contract for sale of property. Removal of lease is one thing, sale of property and seeking permission for it is altogether different thing. Those two conditions can it be bound under section 13 subclause 1b of the specific performance specific relief act has to be seen because 13.1b says where the concurrence of other person is necessary for validating the title, they are bound to concur at the request of vendor or lessor. Here they would refer to the authority who would be willing to provide, who would be providing the
Confidence.
whether the state government in this specific condition is bound to consider the renewal and the permission to grant the permission to sell the property. Given that no history has been shown whether the suit property is a saleable property by nature of its continuous transfer, that is a point which has to be seen.
It's not a continuous transfer.
So once it is admitted that no continuous
Is it your case in the written statement that this agreement is void?
No.
It is not your case. You say that unless the renewal application is allowed, it cannot be granted at best.
At this time, and whether
So what he is saying is that there can be a direction for grant of renewal.
so grant of renewal is one thing, and then a permission would be a second process.
Permission was also
No, it was never.
no application for permission.
No.
It is only the renewal.
Yes.
Unless there is renewal, there is no question of in connection with the second property also where the permission was granted,
Yes.
where the renewal was granted,
Yes.
right? No application for permission was moved.
No.
There is no application for permission.
Nothing on it.
Is that correct? There is no application for permission.
We have not filed any evidence.
No, I'm asking you.
No.
There is no application for permission.
That's why relief was sought by directing me to execute after taking permission. That can only be done. इसलिए वो है कि वेंडर जब रिन्यूअल करा लेंगे, परमिशन के लिए फाइल करना हो, परमिशन लेकर के हमको देंगे. इसलिए मैंने क्लाउज पढ़ाया था माय लॉर्ड कि जितना फंड आएगा हम देने के लिए देंगे. It was the necessary term.
For seeking permission.
हाँ.
Or for seeking renewal.
दोनों परमिशन का भी बात नहीं है उसमें. 17-12 में क्लाउज नंबर 2 है और क्लाउज नंबर 6 है. कि जो भी फंड होगा हम करेंगे, परसू करेंगे, लेकिन एप्लीकेशन कौन फंड का ये देंगे, आगे बढ़ेंगे, ये करेंगे. उसी टर्म इसलिए वही शुरू में कहें कि अगर बियॉन्ड टर्म कंडीशन एग्रीमेंट हम नहीं कर सकते.
That's all. First appeal number 138 of 2023. Heard the learned counsel appearing on behalf of the appellant. And counsel appearing on behalf of respondent number 1 and 2. In spite of service of notice through paper publication,
हाँ.
upon
Order must be
substituted service of notice to paper publication on respondent numbers 3 and 4. They have not entered appeals. This appeal has been filed against the judgment and decree dated 29/4/2023, within bracket decree signed on 9/5/2023, bracket close, passed by the learned civil judge within bracket senior division bracket close Roman 6 Hazaribagh, whereby original within bracket title bracket close suit number 154 of 2016 has been dismissed. The records of the case reveal that in the original suit there were only 3 defendants. Defendant number 1 and 2 were Deputy Commissioner and Khasmail officer respectively, and defendant number 3 was one Randeep Lahiri, who was substituted before the court on account of his death by the order dated 18/12/21, and the proceeding was set ex parte by the order dated 27/9/22. The records further reveal that as well as that the original defendant number 3 had appeared before the learned trial court and had filed a petition under Order 7 Rule 11 CPC on 29/4/2019, stating that the suit itself was not maintainable. And making a prayer for rejection of plaint. But the said petition was rejected by the learned court by the order dated 3/12/2019. And ultimately he was substituted, and then the proceeding was set ex parte against the substituted legal persons. The title suit was filed on One 9/2016. The defendant number 2 and 1 and 2 had filed their written statement. Both of them had filed their written statement. डिग्री से देखिए ना Date of institution is 4/10. The suit was instituted on 4/10/2016. The suit was filed seeking specific performance of contract of sale dated 17/12/2014 said to have been executed between the plaintiff and the original defendant number 3. The relief is quoted as under. The property consisted of in two parts. One was Schedule A and Schedule B, which is also quoted as under. As per the case of the plaintiff, Ranjit Lahiri and his brother Abhijit Lahiri were the lessee of the Khas Mahal building lease holding number 242. And also lessee of land of 2.04 acres bearing holding number 243, which were fully described in Schedule A and B of the plaintiff. ये बिल्डिंग लीज अलग से
यहाँ पे बिल्डिंग रहेगा, वो बिल्डिंग लीज है। जहाँ पे लैंड है उसको
बिल्डिंग लीज वाज ओनली इन कनेक्शन विद शेड्यूल बी प्रॉपर्टी, शेड्यूल ए. The specific case of the plaintiff was that building lease was in relation to Schedule A of the property and orchard lease was in connection with Schedule B. It was asserted that the building lease was in the process of renewal for the period from 1/4/2008 to 31/3/38, whereas the orchard lease stood renewed till 31/3/2038. On the basis of offer of defendant number 3, the plaintiff entered into an agreement for a consideration amount of rupees 76 lakhs and they agreed to prepare an instrument to this effect. On 7/3/2013, they executed an instrument and the consideration amount of the property was rupees 76 lakhs, out of which the plaintiff paid rupees 9 lakhs and rupees 8 lakhs. Rupees 9 lakhs in favor of Ranjit Lady and rupees 8 lakhs in favor of his wife Lekha Lahiri through checks. And further rupees 8 lakhs in favor of Arijit Lahiri, son of Ranjit Lahiri. And these checks were cleared. And it was agreed that the agreement of sale will be executed. Upon demand made by the defendant number 3, the plaintiff further paid rupees 25 lakhs through checks, whose details have been mentioned in paragraph 6. Further, the plaintiff claimed to have paid rupees 2 lakhs in cash upon the defendant number 3 on 15/12/2014 at his residence at Kolkata. It was his further case that after encashment of the various checks and upon payments as stated above, the plaintiff and the defendant number 3 entered into an agreement dated 17/12/2014, wherein the consideration amount of the land was fixed at rupees 75 lakhs, out of which the plaintiff had already paid 48 lakhs by checks and 2 lakhs in cash on 15/12/2014. It was further asserted that just before execution of the agreement to sale, the plaintiff further paid rupees 8 lakhs in cash to the defendant number 3 and handed over 3 checks totaling rupees 15 lakhs as security, which was to be honored at the time of execution of the registration of power of attorney in favor of the plaintiff after the renewal of lease in connection with Schedule B property, as the lease was already renewed in connection with Schedule A property. It was asserted that the land and the premises stood renewed from 1/4/2008 to 31/3/38 in the name of defendant number 3 and Abhijit Lahiri, who is the own brother of defendant number 3. अभिजीत लहरी को पार्टी नहीं बनाए थे ओरिजिनली,
नहीं पार्टी उसके साथ एग्रीमेंट नहीं,
ये कैसे हो?
उसके साथ
उसके साथ
एग्रीमेंट
एग्रीमेंट नहीं था तो वो पार्ट कैसे होगा?
पार्ट तो होता है पर इसी को आप जो माइनर में लगे सेक्शन 44 ट्रांसफर ऑफ प्रॉपर्टी एक्ट रीसेंट जजमेंट माइनर है
undivided portion.
लिखा हुआ भी वही है.
The building lease, the renewal of building lease was under process. It was the case of the plaintiff that since renewal of the building lease was under process, defendant number 3 had asked the plaintiff that transfer application will not be sent to Khas Mahal office, and he assured the plaintiff that he would execute the power of attorney soon after being informed of the renewal of the lease in his name. And he would realize the balance consideration amount of rupees 25 lakhs from the plaintiff. The defendant number 3 had requested the plaintiff, in terms of the agreement, to pursue the renewal process of Schedule A land before the Khas Mahal authority, and it was only by virtue of the hard endeavour of the plaintiff that the orchard lease got renewed for the period from 1/4/2008 to 31/3/2038. The renewal application were numbered as case number 46 of 2007-8 and 47 of 2007-8, and it was sent to the Revenue Secretary Ranchi after getting all the formalities completed at Hazaribagh from Khas Mahal officer to Commissioner North Chotanagpur Division, Hazaribagh. The plaintiff followed up the matter for renewal, and the plaintiff was kept under an impression that when the building lease gets renewed, he would get the land and premises transferred in the name of the plaintiff. It was also asserted that the plaintiff started putting his effort in gathering rupees 25 lakhs to be given to the defendant number 3 in future. And on this basis, it was asserted that the plaintiff was very much willing and even ready to purchase the half share of the defendant number 3 in Schedule A and Schedule B land. The plaintiff also stated that there was sharp rise in the land prices and the price of Schedule A and Schedule B increased many folds, which made the defendant number 3 dishonest on account of escalation of price of the scheduled property. Suddenly the cause of action arose when the plaintiff on 25/6/2016 saw that some unknown persons inside the premises of Schedule A and Schedule B had entered and making certain construction, and upon the query on the part of the defendant number 3, and the defendant number 3 failed to give any satisfactory explanation to the plaintiff. The plaintiff asserted that it was necessary to restrain the defendant number 3 from transferring, selling and assigning any or alienate any part of the suit land or entering into any agreement or change the effect or make any changes with respect to the suit land. It was also asserted that any subsequent agreement of sale or power of attorney with respect to the suit land be treated as void. It was further asserted that defendant number 3 was deliberately avoiding to perform his part of the contract dated 17/12/2014 out of greed and extraordinary escalation in the price of the land. It was asserted that the plaintiff had performed his part of the contract by paying 58 lakhs to the defendant number 3, and the agreement of sale dated 17/12/2014 did not envisage any other steps to be taken by the plaintiff till the receipt of intimation from defendant number 3 about having obtained all the requisite permissions, and that the plaintiff till the date of filing of the suit had not received any intimation despite repeated request and reminder to the defendant number 3. It was asserted that the plaintiff was throughout ready and willing to perform his part of the contract from the date of the execution of the instrument on 7/3/2013 and also the agreement dated 17/12/2014 and was having the means and resources to pay the balance consideration amount at the time of registration of the sale. Ultimately, the plaintiff sent legal notice to the defendants on 29/7/2016 by its speed post, which was duly received by defendant number 3, but no response was given to the plaintiff. The matter was also brought to the knowledge of the Deputy Commissioner Hazaribagh and Khasmail officer, but nothing happened. Section 80 CPC notice
Yes.
लिखा हुआ नहीं. The cause of action arose on 7, as per the plaintiff, the cause of action arose on 7/3/2013 when the instrument was duly executed between the plaintiff and the defendant number 3, and on 7/12/2014 when the agreement of sale was entered into between the parties and day to day thereafter, and lastly on 29/7/2016 when the legal notice was issued and continuously thereafter. The plaintiff asserted that the plaintiff is still willing and ever ready to purchase the Schedule A and B property and ready to give the balance 17 lakhs consideration amount to the defendant. The defendant number 1 and 2, they filed their written statement stating that the suit was not maintainable and there was no cause of action and was bad for non-joinder and misjoinder of necessary parties. It was also asserted that the suit was barred by limitation. It was asserted that the plaintiff had not properly valued the suit property and the real market value of the property was more than rupees 1 crore. It was asserted that the defendant number 3, Ranjit Lehri and his brother Abhijit Lehri were not lessees in respect of the Khasmal plot number 59/1564 under building leasehold number 243 and altered lease plot number 59 of 1564 under holding number 243. And the plaintiff had no knowledge about the correct plot numbers of the leaseholding in the name of defendant number 3 and his brother. Khasmal lease exhibit कराएं? तब it was asserted that as per the records of the Khasmal office, Ranjit Lehri and his brother Abhijit Lehri are lessees in respect of building leasehold number 242, plot number 58 of 1564, area 1 acre, and orchard lease holding number 243, plot number 58/1566, area 2.04 acres. The description of the plot given in the schedule A and B land was said to be incorrect.
होल्डिंग नंबर है, होल्डिंग नंबर
But the description of the plot is incorrect. The description of the property is incorrect.
हाँ लेकिन होल्डिंग नंबर है बाउंड्री से
We proceed tomorrow.
पहला नहीं एक जजमेंट तक 2007-10 के दे पैराग्राफ दे नहीं दे मैं प्री कंडीशन तो नहीं मेरे से
कल रहिएगा, दे दीजिए। ये जितने भी आपके जजमेंट्स हैं ना,
जी
इन सब में जो आप साइट कर रहे हैं,
जी
उसको आप ऊपर पैरा नंबर लिख के देंगे
जी,
हमको, और जो नहीं साइट कर रहे हैं
जी
उसको खाली क्रॉस कर देंगे, वापस मत ले लीजिए।
नहीं ग्रेट